Okay, hello everybody. Welcome to the next in the series of Birketts webinar series. My name is Patrick Cooney. I'm a partner in the construction and engineering team at Birketts, and I'm chairing today's webinar, including the Q&A session at the end. Our speakers will talk for about 45 minutes or so to leave 10 or 15 minutes for questions at the end of the session. So please feel free to ask any questions using the Q&A button at the top of your screens during the course of the presentation. So thank you for this opportunity to present to the Chartered Institution of Civil Engineering Surveyors. I think we'll go with CSES. That's quite a mouthful. Hopefully Birketts is familiar to you now. Hopefully this isn't the first webinar you've seen from us. Not going to give you the hard sell about Birketts, but in short, we're a full service top 50 UK law firm with over 1,200 staff and offices across East Anglia and London, Bristol and Sevenoaks. On the slide there, you can see our speakers for today. I shan't introduce them because they shall do that themselves, and I'll give you a little précis about what each speaker is going to cover today. So Chris is going to talk to us about the new target cost contract from the JCT. Sara and Naomi are going to talk to us about procurement reform and practice with some key developments and some practical insights. And Milana is going to wrap us up with a review of some recent case law highlights. So without further ado, I shall hand it over to Chris, who's going to talk about the new JCT target cost contract.
Thank you, Patrick. Good afternoon, everyone. I'm a legal director in the construction group here at Birketts. And as Patrick says, we're going to be talking about the new JCT target cost contract, or TCC, as I'll refer to it. But firstly, because some of you may not know, I thought I'd just say some words about what is a target cost contract. So target cost contracts are a form of cost reimbursable contract, with the starting point being that a contractor is paid on actual costs for the carrying out of the works plus a fee. So there's no fixed cost for the works is agreed up front. Instead, the parties will agree an estimate of what they believe the works will cost, this being the target cost. Now, the target cost should reflect a genuine and properly substantiated estimate of the likely cost of the works, and it should be developed between the parties on an open book basis. Getting this target cost as accurate and realistic as possible is therefore critically important in any project, as it serves as your financial baseline against which the success of the project is judged. So this upfront target cost is then typically adjusted during the construction of the works to account for things like variations and delay events, much like a fixed cost will be adjusted under other forms of contract. So this adjustment process will ensure that the target cost accurately reflects the anticipated and estimated cost of the works, and the contractor is not unduly penalised due to events beyond its control where it's required to incur more costs than originally allowed for. And this may happen under the pay and gain mechanism, which we'll talk about later. So the contract price is then based on the actual cost plus fee. And breaking that down, the actual cost here just means the costs incurred by the contractor in carrying out and completing the works on a pound for pound basis. And the fee then is a pre-agreed fee, which covers contractors' profit and overhead costs, as well as any risk allowances, and can be expressed as either a percentage or a flat rate. And this is applied to the contractor's actual costs to provide the overall amount payable. The parties can also agree up front what disallowed costs will not form the actual cost. So that is costs not directly related to the works or that cannot be substantiated as having been incurred, and these disallowed costs will not be payable to the contractor. So you'll appreciate then that open book accounting should be used, whereby the contractor's accounts and records are regularly reviewed and assessed during the construction phase and up to final account to ensure that any actual cost applied has been properly incurred and isn't disallowed cost. And finally, following completion of the works, the final cost for completing everything, or the actual cost plus the fee, is then assessed against the target cost to determine whether the final cost of the works is lower or higher than the target cost. And under a target cost model, any pay and gain against the target cost for the works is shared between the parties in pre-agreed proportions. Now, some contracts assess pay and gain on a continual basis throughout the delivery of the project, and others solely at the end of the project, and the mechanism just simply depends on what the parties agree at the outset. So, moving on, we know that in the main, JCT uses fixed price contracts. So, why has it decided that now is the right time to introduce a target cost contract within its 2024 suite? And to do that, well, let's look at what JCT itself says. So firstly, JCT said it wanted to encourage collaboration in construction projects, and it sees collaboration as being achieved by encouraging open book accounting, transparent cost reporting, and promoting cooperative practices to maximize opportunities for cost savings and reducing adversarial relationships. Secondly, JCT wants to improve cost transparency by the open book approach to valuations, meaning the contractor must provide detailed records of actual cost incurred and allow the employer to have inspection rights to verify those costs. This ensures transparency to what is being claimed and reimbursed. Thirdly, JCT has suggested that in the current economic climate, with contractor insolvencies on the rise, a target cost model moves away from traditional lump sum contracts where the contractor bears most risk and distributes financial risk and reward between the employer and the contractor. Therefore, in JCT's eyes, the contract is designed to motivate contractors to control costs by introducing a target cost and a pay and gain share mechanism. So putting this all together, collaboration, greater cost transparency and sharing of risk, JCT believes should lead to an improved project delivery. And JCT also wants to impress on the industry that the TCC aligns with construction playbook principles for collaborative contracting. So that sets out what JCT suggests is the objectives behind this new form, but as an observer, I would also like to think that JCT as a commercial organisation is putting out this form to offer an alternative to an NEC target cost contract, making JCT perhaps more competitive in the market. So I'd like to move on now to what is in the TCC contract, but in the short time we have, I can't go through the TCC clause by clause, but helpfully JCT has confirmed that the TCC is based on a JCT design and build form, so it retains the same risk profile as with its D&B form, but with a redrawn payment process. So let's focus perhaps on the key payment mechanisms. So firstly, the target cost. And in all other JCT contracts, as people will know, these contracts include a fixed contract sum. However, TCC has a target cost, which must be stated in Article 2. And under TCC, the target cost is established by the contractor issuing its target cost proposal, supported by what's called target cost analysis. So for the employer, this will mean that the employer's requirements should set out in detail the parameters within which the contractor should base its target cost proposals, including the format and level of detail required for the target cost analysis. So JCT itself recommends that the target cost analysis is as detailed as possible, and the employer's requirements are prescriptive as to the format and the level of detail required. Now, in terms of adjustments, the target cost is adjusted in a similar way to adjustments for a contract sum, in other JCT contracts. And Schedule 1 in TCC sets out the circumstances in which a target cost can be adjusted. And you won't be surprised that these include changes, acceleration quotations, fluctuations, sundry payments, costs of suspension by the contractor, and loss and expense claims. Okay. The second key payment mechanism I want to look at is allowable cost. And this is calculated in accordance with Schedule 2, which if we look at in a little bit more detail, we can see this comprises of 7 parts. The first part comprises various general provisions, including those relating to lump sums in lieu of actual cost. Now, JCT's guide to the TCC explains that having lump sums simplifies the calculation of allowable cost and requires less administration. However, it seems to me that By moving away from actual cost and using a fixed price approach or a cap where there's maximum amounts are listed, this probably detracts from the incentive to getting the parties to collaborate. And in effect, you might be moving back to a fixed price contract. Second part of Schedule 2 relates to subcontract works, costs which are due and payable under the subcontracts, but not costs which are due to contractor default. The third part relates to contractors' management and design staff on site, where under this part, the contractor is expected to provide a list of directly employed management and design staff, including relevant terms and conditions of employment, as payments in respect of salaries and items such as bonuses, contributions to pension scheme, etc., are all considered allowable costs. Now, this will obviously require substantial disclosure by the contractor that would be regarded as confidential and even subject to data protection regulations. The next part is the contractor's direct workforce on site, so all other staff that are not management and design staff. Parts 5 and 6 relate to materials and goods and plant, services and consumable stores provided by the contractor. And the allowable cost here is based on actual costs, net of any trade discounts or current market prices that are provided by the contractor. And the final part of Schedule 2 relates to sundry costs incurred by the contractor. So under TCC, the parties must identify where the details are documented for the calculation and verification of the allowable cost, and the contractor has to keep the records open for inspection. But if the parties want to include a category of cost for their project in Schedule 2 that is not already included, then this can be done by specifying within the required entry in the contract particulars any agreed modification to the provisions of Schedule 2. And Schedule 2 also sets out the exclusions to the calculation of allowable costs, including costs that are not properly substantiated by the contractor's records, costs of making good, breaching subcontract requirements, and any discounts received by the contractor or outside agreed categories. Moving on then, the third key payment mechanism is the contract fee, which is intended to generally represent the overhead and profit element that is not captured in the allowable cost element. Now, JCT here provides two options, a percentage fee or a fixed sum. Where the contract fee is fixed, it can be adjusted to take into account the difference between the original target cost and the final adjusted target cost based on a pre-agreed percentage-based threshold. And this is calculated in the formula, which is set out in Schedule 3. If the parties don't agree the percentage threshold, the default position is 0%, which means that the contract fee is adjusted based on the same proportion as the target cost adjustment. So bearing in mind that the definition of the contract fee makes it clear that it's intended to cover all costs and expenses not covered by the allowable cost, you can see that agreeing that contract fee will be a key commercial issue in any contract negotiation. The last key payment mechanism, therefore, is the difference share, which is essentially the pay and gain mechanism and determines how any savings or overspend are shared between the parties. And as with all commercial agreements, how the parties' shares will be allocated and when this calculation will take place should be agreed up front and in advance. So the share can either be a fixed sum or a percentage, and the contract particulars describe the use of bands that are based on percentages or fixed monetary amounts. And if you were to use bands, you'll also need to agree the employers' and contractors' respective percentages that are applied in any band. So it's therefore possible to agree different percentages for each band. But if not included, TCC has a default position that says where no percentages are stated, then the percentages is a straight 50-50 split. Now, this different share is calculated and applied on completion or termination, if that happens, once the full costs are known and the adjusted target cost is also known. However, TCC does also allow the possibility to provide for the different share to be calculated and applied on a monthly basis as part of each interim payment. And to do this, you need to choose to apply clause 4.7 in the contract particulars. So, having looked at how it works, what are the benefits and challenges of using the new JCT TCC? So, for benefits, TCC clearly encourages collaboration between the employers and contractors by aligning their commercial interests through a target cost mechanism, and this incentivizes both parties to work together to improve project delivery and reduce costs. The pay and gain mechanism aligns employer and contractor interests, promotes teamwork, and incentivizes cost efficiency. And a robust open book accounting process provides greater flexibility of actual costs and promotes transparency, which hopefully reduces disputes and improves trust. And finally, allowing flexibility in calculating the difference share, which can be applied either monthly during interim payments or upon project completion, depends on the parties' agreement. But having seen the benefits, what challenges are there to using TCC? Certainly the requirement for detailed cost records and verification processes, as well as the need to manage adjustments to the target cost and allowable costs, will increase administrative burden. But I guess those teams that already use NEC option C will be used to that increased admin side of it. And as in all target cost mechanisms, one of the commercial challenges is not setting an unrealistically low target cost due to commercial pressures, which can lead to an immediate pain share and undermine perhaps the collaborative intent of the whole contract. And if it's not included in Schedule 2, then it's not an allowable cost. But JCT doesn't have the concept equivalent in NEC to disallow costs, and this may potentially lead to disputes over the recoverability of certain costs under TCC, particularly maybe regarding defects and delays and other discounts. So to finish up then, what can we say about TCC? Well, we can say it's designed for larger or complex projects, often where the contractor completes the design. It's based on the JCT Designer Build Contract 2024, so there's a familiar structure for teams used to working with JCT, but with different pricing and payment mechanisms, and it encourages shared responsibility and transparency. Thank you very much for that. I'll now pass you on to Sara and Naomi, who will take you through procurement reform.
Super, thanks, Chris. I'm Sara Sayer. I'm the partner who heads the Administrative and Public Law Disputes team at Birketts, which covers our procurement disputes practice. I'm just going to take a moment to set the scene on procurement and look at the value of procurement within the UK. Cabinet Office data tells us that external procurement across the public sector accounts for roughly 300 billion of spending per year across all levels of government. Trying to drill down into how much of that is construction related, the last stats that I could get my hands on are the 2023 Office of National Statistics construction statistics that say construction work amounts to about 139 billion of spending each year. And by that, we mean infrastructure, housing and other public works. So construction is a significant amount of annual UK total public procurement spend. Procurement has definitely gone up the government agenda. If we just remind ourselves as to why we procure, the National Audit Office report in July 25 said that effective procurement processes help government secure better value for money by reducing costs, improving quality, and fostering innovation. Enough of the policy. I'm going to hand over to Naomi now, who's going to skillfully take us through key developments and practical insights.
Thanks, Sarah. I'm Naomi Westcott, and I'm a legal director in the Admin and Public Law Disputes team. And I regularly advise both contracting authorities and bidders in respect of procurement disputes. So the first slide I've included here, I thought it would just be helpful for you to see the potential thresholds that might be relevant to contracts that you might be working with. And if your contract value is above the threshold, then contract rules apply. And these figures are relevant and in effect until the end of this year. And then from the 1st of January 26, they may be revised. So watch out for that. And all these figures are inclusive of VAT. So the Procurement Act came into effect in February 2025, and that is a big change. And what's new and does it matter? Well, it replaces the public contract regulations, the PCR, following the UK's departure from the EU, and it reforms the UK system of procurement. So under the PCR, we had the MEAT, which focused on price and cost, the most economically advantageous tender. And that was about the cost as the dominant factor, with quality and social value considered, but often secondary to lowest cost. Under the new regime, we have the most advantageous tender, which is about the best overall outcome. So it's not just economic. And that allows greater weight on quality, innovation, sustainability, and social value. So price is still relevant, but it's not the sole driver. And that's an important consideration when bidding on construction contracts. Under the new Act, there are new objectives. And these are the Section 12 objectives, which are listed there for you on the slide. Of those, what's new and what wasn't in effect under the PCR is public benefit and reducing barriers for SMEs. So that's something to look out for. Also new is the debarment list, which is the creation of a centralised debarment list, and that has serious consequences for anyone that's on it, because you can see yourself debarred from all public tenders. It's yet to be seen in practice, though, how that's going to play out. For example, with the Grenfell Tower tragedy, those suppliers involved in that aren't on any list because that process has been paused pending the criminal investigations. There's also increased transparency obligations as listed there for you on the slide, because one of the key aims of the Act was to create a fully transparent public procurement system such that everybody could understand what the UK public sector wants to buy, how much it is spending, and with whom. So, some practical insights about what the new Act might mean for challenges to procurement decisions. Why is it important to you? Well, you've spent all your time putting in your bid and then you get the outcome, and hopefully you've been successful, but not always. And if you haven't, you need to quickly establish whether or not you have grounds to challenge that decision. And common grounds for challenge are set out here for you on the slide. So we have evaluation errors, and that's the misapplication of scoring, undisclosed criteria, benchmarking, unclear criteria, and wrong weightings. And just to stop there, it's important to say that we haven't actually seen that many challenges under the new Act because of the number of frameworks still being used under the old PCR. And case law is still awaited under the Procurement Act, with only a handful of cases issued at High Court and no judgments yet. Nonetheless, it's still expected that evaluation errors will continue to be a really key area for challenge. And examples we've seen recently of evaluation error challenges is misapplication of scoring criteria, where we acted on behalf of a contracting authority that had a challenge brought against them for benchmarking. And what was said was that the evaluators weren't marking the bid against the criteria, but they were marking the bid against another bidder. So they'd seen an idea and then they were marking someone else down for not including that idea. And that's not permitted. You cannot move away from what's set out in the ITT. And if you get a challenge potentially like that, then we can help you look about whether or not it's going to be successful. So what will the court look at when deciding whether or not an evaluation error has grounds to be challenged? Well, it will look at manifest error. And under the PCR, that was manifest error, and that was an obvious mistake. And it was always another way of saying irrationality. And that's the new test under the Procurement Act, which will move away from manifest error. So what is irrationality? Well, it's a decision that is so unreasonable that no reasonable person could have made it. And it's a really high threshold. The court will not substitute their judgment for evaluators unless there is a manifest error or irrationality. So, as a practical tip, you need really strong evidence. A mere disagreement with evaluator scoring is not going to be sufficient. And just there on the slide, I've set out some other potential areas of challenge, which are transparency failures and also equal treatment issues. The Procurement Act. Unequal application or preferential treatment is unlawful, and that overlaps often with the evaluation errors points I've just described. An area we might see an increase of challenges though is debarment, because if you find yourself on a debarment list, then that's something that you're likely to want to challenge if you don't think it's justified. But even under the old PCR, we also saw wrongful exclusion challenges, and that's something that we recently acted on behalf of a construction company dealing with a challenge. And what happened there was that they thought the successful bidder shouldn't have progressed past the selection stage for failing to meet the financial standing requirements. And so it shows you that there are different areas that you can challenge within the different progress sections of the procurement. So a really key message for anybody thinking about challenging is that time is absolutely key. The clock is ticking from the moment you find out the outcome of the procurement decision. So under the PCR, that was 10 calendar days between standstill letter and contract signing. And under the Procurement Act, that's 8 working days, which starts from the contract award notice publication. But don't get caught out, because there is also another limitation period running in the background, and that's the 30-day limitation period, which runs from when you ought to have known of the grounds for challenge. And it's important to watch out, because that one can't be extended, and you may find that your claim cannot be bought if you are out of time. So if you bring a claim during the standstill period, then you will get an automatic suspension against the contracting authority from being able to award the contract. And that's a really important remedy, because it can have a huge impact on the contracting authority, because they aren't able to progress to make the award. Now, if that happens and they accept your challenge or think that they are in a weak position, then you're likely to be in a good position to be able to negotiate with them and get the procurement rerun or remarked. But if they're confident, then you can expect them to swiftly make an application to court to have the automatic suspension lifted. And under the new Act, we do expect the test to have not changed significantly, such that it will continue for that application to be weighted heavily in favour of the contracting authority. By way of example, in the last year, and these are all under the PCR, but 5 applications have been heard at the court in relation to an application to lift the automatic suspension. And of those, 4 have seen the awarding authority succeed, with only 1 application successfully resisted by a claimant. And that's important, because if the automatic suspension is lifted, then that leaves you as a claimant with only a claim in damages. You will not be able to get the contract awarded to you. So some practical tips from me finally for bidders. Early engagement is key. Clarify ambiguities during the tender stage. Why? Because you can't complain later because of the 30-day limitation period. So use the clarification questions and check all published Q&A to ensure your submission aligns with the authority's response. And if it's helpful, the contracting authorities, the advice is ensure a robust audit trail for evaluation documents and decisions, because the court will allow a wide margin of discretion to contracting authorities in evaluation if there's a clear record of decision making in the evaluation, and therefore you can resist any challenge on the basis of manifest error, irrationality, or breach of duty. Thank you. I'm going to pass back to Sarah now.
Thanks, Naomi. So I've been practicing for 25 years, and over 15 of those years have been doing procurement disputes. And sometimes you really do need to see it to believe it. So in my time, our clients have complained of brown envelopes being given to markers, a car that was bought for a marker, a formula that was wrong, meaning the maths in every single bidder's tender was wrong, maths and scoring errors aplenty, and the relative of a bidder actually being one of the moderators. And some of these are on household name procurements. So as Naomi said, one of our key tips is to speak to us early. Now, we commonly hear, especially our corporate clients who are the bidders, saying, oh, well, we know something's gone wrong. We've probably got some evidence of it, but actually we don't want to rock the boat. It's a small industry. If we challenge it, we'll probably never work in that industry again. What we would say to that is we have ways and means of saying and doing things to keep that relationship alive, because we ultimately recognise that you're bidding because you want to work for and with that contracting authority. And so we factor that into our advice and into our approaches. Now I'm going to hand over to Milana for a case law update.
Thanks very much, Sara and Naomi. I'm Milana Masterson, and I'm an associate here in the construction team at Birketts. And thanks for that introduction. I'll be taking you through a few recent cases to give a bit of a snapshot of what's happening in the construction industry from a legal perspective. So the first of those cases is Malice and Persimmon Homes. The facts of this case are relatively simple. Mr. Malice bought a family home from the defendant, who is Persimmon Homes, and shortly after purchasing this home, Mr. Malice became concerned about the amount of cracking in the plaster on the walls. It was actually common ground between the parties that the cause of this cracking was by Persimmon Homes, the developer, because they dug the trench strip foundations too shallow for the ground conditions, which was London clay, and this cracking was actually exacerbated by tree removal. On this basis, Malice, so the purchaser of the home, commenced proceedings against Persimmon Home. Mr. Malice commenced proceedings against Persimmon Homes, who was the developer, on two bases. One was breach of contract, and the other was under Section 1 of the DPA. In this case, Persimmon Homes actually admitted to both these breaches, so it was never an issue whether they breached the contract or the DPA in this way. And although the court didn't go into it, they gave a nod to the benefit of the DPA as having this 30-year limitation period, which is quite helpful, but it never fell to pass in this case because it wasn't the subject of the dispute. Rather, the key question for the court in this case was what was the appropriate remedy in the circumstances. So Mr. Malice, the purchaser, contended that only the complete demolition and rebuild of the property was appropriate, and that's the only thing that could put them back in the position that they should have been in. And as you might expect, Persimmon Homes rejected this and said, no, that's too extreme. That's disproportionate to the actual damage. What essentially repair works need to be done. So the core question for the court was, what is the appropriate remedy in the circumstances? The court actually agreed with Persimmon Homes, and they said, look, looking at the evidence, it seems that it would be disproportionate and unreasonable to order a complete demolition and rebuild of the property. And important to note here is that that key consideration for the court in assessing remedies is the proportionality question. Another very important point to notice here is that the court is really tied to the evidence in the case. So they're not going to engage in speculation. They'll be tied to the evidence of the extent of damage to the property. So in this case, for example, there was evidence that the property was generally fit for habitation, except for that porch area. So the court endorsed on that basis what they termed the robust and technically appropriate approach, was that said, okay, knocking down and rebuilding is disproportionate in these circumstances because the whole property isn't unfit for habitation. It's just this porch area. So they essentially underpinned certain areas of the property. So that's essentially, and we've gone through those key takeaways of proportionality is the kind of the upshot of that's the key consideration for the court, and evidence is really important. So the practical importance of documents and taking records at the time. The next case that I'll turn to is VMA and POL. By way of high-level upshot, it's about the enforcement of an adjudicator's decision. The facts are relatively simple. So in October 2013, the parties entered into a JCT contract for the design and installation of mechanical works in London. VMA submits a payment application for about £106,000, as you can see in that middle pane there. And crucially, and this is a very important point, POL, so the employer in that case, does not submit a pay less notice or payment notice. However, they do just commence a true value adjudication. They said, okay, we can't agree on the value of the dispute. Let's bring it to adjudication, exercise our rights under the Act. That next slide, I've stepped out the operative payment mechanisms. I won't go through them in too much detail given the time, but they are the relevant provisions there. So what actually happened here is the adjudicator decided in favour of VMA. And they said, look, because you, POL, haven't submitted a payment notice or a pay less notice in response to VMA's payment application, so for that £106,000 figure, that constituted a complete defence to the true value of adjudication. Essentially, the failure to make that pay less notice meant that that £106,000 figure was a notified sum and an immediate payment obligation upon POL to pay it. And on that basis, they couldn't commence a true value adjudication. Then this then goes to the court, as you might expect, and it's the question of enforcement. Can this adjudicator's decision be enforced? And POL tries to avoid enforcement on the basis that they don't have jurisdiction in the way that they can't, the immediate payment obligation isn't an offence in this way. The court essentially agrees with the adjudicator. And this is what they term the principle of subjugation, but functionally it's the same as the adjudicator's decision below. It steps it out in a little bit more detail here. So essentially where the contractor issues a payment application asserting that they're due a sum, so this is the notified sum, so in that case that £106,000 odd figure, if the employer then does not issue a pay less notice in the way that they're supposed to in the Act, this then triggers that immediate payment obligation. So essentially, by default, the employer is obliged to pay that notified sum figure, and this is what we term a smash and grab adjudication. Of course, then the employer also has a right under the Act to commence a true value adjudication. So if you've got a dispute crystallising, you can refer to adjudication to assess the value of the dispute. However, when you have these two competing payment obligations, so on one hand you've got the smash and grab adjudication where the employer hasn't paid the notified sum and hasn't submitted a pay less notice in respect of that, and on the other hand you've got the employer's right to a TVA. So the question for the court was, well, how do we marry these up? What's the architecture of the Act? How does this all fit together? And this essentially, reiterating the adjudicator's decision, the employer's right to a TVA is subjugated to the immediate payment obligation to POL. So in this way, they did agree with the adjudicator that the failure to submit a pay less notice or a payment notice to the notified sum, to the payment application, was a complete defence to the TVA in this way. And the POL was not successful in avoiding enforcement in those circumstances. You can see that quote on the last pane of that slide, that it would be an arid exercise to require VMA to commence another adjudication to recover a sum which has already been determined to be due to them. So that's a reference to that immediate payment obligation by virtue of the failure by POL to submit a pay less notice or a payment notice. So what this really underlines is how important it is for both contractors and employers to really keep on top of the deadlines in respect of those payment obligations of the Act. The last case that I'll go through, the facts are a little bit more complex, but we'll step it through. It also concerns the enforcement of an adjudicator's decision, but on a different basis. So on the basis that the adjudicator has breached natural justice. So the facts of the case are these. Broadly, it concerned the design and construction of a leisure and retail centre in Bishop Auckland. After practical completion, Clegg, who was the claimant, and also the contractor in this case, issued a payment application. Unlike in VMA and POL, the defendant then did submit a payment notice, so there was no issue of the principle of subjugation here, but nevertheless a dispute did crystallise in relation to the value of that application, and Clegg referred it to adjudication. The crucial point to notice here is how prolonged these adjudication proceedings were. So generally, adjudication is supposed to be this quick justice, kind of this rough and ready remedy. It's not perfect justice in light of the aims of achieving, promoting cash flow, achieving efficiency to get the ball moving. However, in this case, the decision was given 87 days after the referral, so a very, very long process. And importantly, in addition to the usual rounds of submissions you expect in adjudication, so in addition to the referral, response, reply, they also had rejoinder, sub-rejoinder, and then also additional rounds of submissions. So the parties had plenty of opportunities to provide submissions. What happens next is the adjudicator decides in favour of the claimant, in favour of Clegg. After this 87 days, they give a decision. The defendant, not being successful, reads the decision and go, well, we can't figure out how you've come to this valuation. We can't figure out these workings. And then after the decision, they actually request the adjudicator, say, well, can you just provide your calculations? Can you provide your workings so we can understand how you've come to this valuation? And the adjudicator does. They give them their additional calculations, how they came to it. And when reviewing them, the defendant goes, well, hang on, you've used this new, what they've termed a fair and reasonable rate. Neither of the parties had submitted this rate. It was not smack bang in the middle. It wasn't the crude split the difference between the two parties' rates. It was this new rate that the adjudicator had used for the decision. And as you can expect, when Clegg tried to apply for the court for enforcement of that decision, the defendant Prestige sought to avoid enforcement on the basis that the adjudicator had breached natural justice, and that's on 2 grounds, as you can see on the slide here. So the first ground is that the adjudicator had failed to give the parties an opportunity to comment on this fair and reasonable rate. So they're saying, well, the fact that you've only given us these calculations after the decision, how could the parties have an opportunity to comment on whether we think that rate is appropriate? The second basis was, well, you haven't provided the adequate reasons for this decision, Mr. Adjudicator. So essentially, because we had to ask you for your workings after your decision was made, surely that must mean that in your decision you didn't provide adequate reasons. The court was not convinced. The court ultimately decided there was no breach of natural justice in these circumstances, and that was not a basis to avoid enforcement. This case is really quite useful in stepping out the principles and the details of breach of natural justice. In the sake of time, I won't go through them all here, but if you are looking at this issue, I'd really recommend and point you to paragraphs 10 and 11 of that case. Paragraph 10 summarises the key cases in this area, and 11, they distill the principles and set out quite clearly what the court will be concerned with and the key considerations in determining breach of natural justice. I'll pick out a few here, as I said. First of all, the court was really quite swayed by how broad the wording of the parties' submission documents are. So rather than the claimant saying, we think the valuation is X, defendant saying, we think the valuation is Y, both parties in those documents actually said, we think the valuation is X or Y, or other such sums as the adjudicator shall see fit, as you can see on that slide there. So they've given the adjudicator quite a broad remit or a bandwidth to make their decision. Importantly for the court, they were quite critical of the defendant of being granular. You can see that here of wrong to adopt an overly granular approach in light of the aims and purposes of the Act. So essentially it's this key consideration of the objective of the Act is to promote cash flow, it's to be efficient. The adjudicator is not required to set out every element of their thinking. That would defeat the objectives of the Act. And the idea that the adjudication is this kind of quick justice and it's not perfect justice. The court was also quite critical in saying, well, defendant, you're actually the one who asked for the additional information after the decision. And the fact that the adjudicator gave them to you shouldn't mean that you can then avoid enforcement on that basis. And again, as the last point, quite crucially, the defendant did not convince the court that they'd suffered any substantial injustice. So when the court was looking at this new fair and reasonable rate that, as termed by the court, that the adjudicator had adopted or kind of crafted themselves, they actually found that in certain circumstances that rate was actually beneficial to the defendant. So in those circumstances, they couldn't demonstrate that they'd actually suffered any substantial injustice, and that was what was required to prove that there's been a breach of natural justice by the adjudicator. So in terms of high-level takeaways, natural justice is a very high bar. It's very difficult to avoid enforcement on the basis of a breach of natural justice. And I've set out there that you need to not only show that there's a breach of natural justice, so that's a exquisitely fact-sensitive query, so it will turn on the facts of the case, but you also need to demonstrate that you've suffered some sort of substantial injustice. And then lastly, from a very kind of practical perspective, when you're drafting the referral documents and the response documents to the adjudication, obviously you generally have quite a short time frame and it's generally a little bit of a rush, but you do need to be very careful in how you define the breadth and the scope of the adjudicator's remit, because that will actually have quite substantial consequences. So in terms of a very high level wrap up of the key takeaways from those cases, and I think that are quite important recently. Firstly, and this harks back to that VMA and POL case that I went over at the beginning, it's really important to make sure that you're very abreast of the deadlines in respect of complying with the payment mechanisms. So have diarised somewhere of by X date we need to respond to, we need to provide a PLN or we need to provide a payment application, those sorts of things. Have some of that, you can have regard to that quite clearly. Second of all, as we've just gone through, it's quite difficult to prove that there's a breach of natural justice or a lack of jurisdiction to avoid enforcement of adjudicators' decisions. And lastly, this was briefly touched on in that first malice and persimmon case, if you are coming up against difficulties and time bar issues, so for example, if you're trying to pursue a tortious claim or claim in contract and you're worried about time bar issues, it is worth your while to see if you have a breach or a claim under the DPA, given that the 2022 amendments to the BSA did extend that limitation period to 30 years. So you might have some recourse there if you're being time barred out of other claims. That's it for me. I'll pass you on to Patrick for any questions.
Thank you, Milana. We've had some questions sent in ahead of the session, so let's just cover those in turn. First one's on the procurement side, so one for Sarah or Naomi. If you're an unsuccessful bidder trying to get hold of or trying to assess the merits of a challenge, how do you get hold of documents from a contracting authority?
Yeah, it's a very important point because as a challenger, you're in a bit of a vacuum in terms of information. So